This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
The questions in these presentations sometimes have the best information for people who are listening in. What I'm going to do is I'm just going to read the question quickly and then provide a quick answer. So the first question is from George. How should an HOA advise the community if a resident has COVID-19? What liability does the HOA have? Good question. So if your association has verified evidence that you have a resident that has COVID-19, you would have to actually verify that with that resident or with a relative of that resident. The association can put out a notification to the community just saying we're letting everybody know that a resident in the community has tested positive for COVID. Please be careful. Wear your mask, socially distance. You should not be using that resident's name. You might want to reiterate what CDC cleaning standards the association is doing at this time in the community in the letter, and indicate that the association will never be giving out the name of the owner, even if requested. What liability does the HOA have? It's hard to comment because I don't know how, if there's allegations that the owner may have contracted it at a pickleball match at the association or what, but we haven't seen any cases where associations have been sued. I haven't received any demand letters from attorneys for residents that claim, that they received COVID from the association. I think that the liability could be okay, what if the association is aware that a resident attended a pickleball event in the community and another resident was there who had COVID? And do we have to notify the owners? And my feeling would be yes. The association should be proactive and communicate with their residents if there has been any potential exposure or if there could be future exposure. So if you're in that situation, great idea to reach out to your legal counsel and discuss, what would be the best way to handle that situation. Next question is from Travis. Section 33-1249 includes proxies as part of a count to determine quorum at an owners meeting. But section 33-1250 prohibits proxies. And our HOA uses the same language to determine whether we have a quorum. This year, we will not have a quorum because mail-in votes are not to be counted. What should we do? And why doesn't the state change this? Okay, so quick answer on this, Travis, is that proxy voting in Arizona is only allowed under developer control. Once the owners have control of the association, proxy voting is prohibited. And so in those situations where, even in the associations that have developer control, the developers are opting not to use proxy voting, just so you know. Proxy voting is a thing from the past. I haven't seen anyone use proxy voting in a developer-controlled association in years. So every association really should be using absentee or mail-in ballots now. And I'm not sure why you're not counting your mail-in or absentee ballots in your association. You should be. And like I said, when I was talking about annual meetings during the pandemic, it's really important that you are keeping track of those absentee and mail-in ballots about 2 weeks before your annual meeting and determining whether you're going to have enough to have a quorum. And if you're not, you should be reaching out to your owners to ask them to provide the mail-in or absentee ballot so that we can have a quorum. Okay, and why doesn't the state change it? I don't think that they have to because proxy voting is still allowed under developer control. So that section doesn't necessarily conflict. Okay, next question from Rick, one of my favorite clients. Good to hear from you today, Rick. Thanks for being here. Has the governor indicated how many people may congregate in common areas and HOAs? I don't think the governor has specifically addressed HOAs. I know that previously the governor has, made statements that they don't want more than 50 people meeting in any location. In the pools, the governor has indicated that we cannot have more than 10 people congregating in the pool areas and associations. And so I hope that answers your question. Obviously this is not the time to be having a potluck in your association or a pool party. And be mindful that your, signage around your association should be encouraging owners to socially distance. And at the pool, check out our cheat sheet that we've already provided here today on one of our COVID-19 cheat sheets on reopening common areas. We have the exact language that you should have on your pool sign to make sure that you're meeting the governor's required orders. Okay, next question is from David. Considering the Arizona open meeting laws, can an HOA board or its committees agree on their officer positions, such as board president, chair, in a closed meeting by some collaboration outside of an open meeting? Then, if that collaboration outside an open meeting occurs, can the board either vote or simply announce those positions in an open meeting? So, David, I would say that electing officers for your association is not an emergency that needs to be done outside of an open board meeting. So, by collaborating outside an open meeting on a non-emergency subject, you'd be violating the open meeting law. I see that you're going to try to, after the fact, approve it at an open board meeting. That would legitimize it somewhat, but it would be a violation of the open meeting law. The better way to do it is just to have the board elect its officers right at the end of the annual meeting, or do it at the first board meeting after the annual meeting. Okay, what are the legal options for removal of feral cats? That's from an anonymous person. Okay, so well, first of all, I would say that if you have feral cats in your neighborhood, somebody's feeding them. So make sure that you're publicizing to your neighbors that and to your owners that please do not feed the feral cats, because it's creating an issue in our association with an overrun of cats. You can contact the Humane Society to ask what different programs that they have possibly for trapping the cats. But really, if you eliminate the food source, that should solve your problem. But the association trapping, animals, is not something that we recommend. And I would reach out to the Humane Society to see what their suggestions are on this. Okay, Joan, the next question is from Joan. Relative to the bill that would modify the percentage required to modify CC&Rs, does that apply to new documents, or would it only override the percentage requirements in existing documents? That's a really good question. I think the way that it's worded is that it would override any set of CC&Rs in associations. But again, remember, this is just a bill that's pending in the legislature, and that, what actually is the final version of that bill, we don't know. I mean, as of right now, it is just going to lower the percentage requirement to amend the documents to over 50%. But one of the bills that has that in there also has a bunch of carve-in amendments where it wouldn't apply. And one of the carve-in amendments was, on short-term rentals, which is obviously something that associations would have loved to use this particular restriction modification for. So we'll just have to see what happens, but I think it would apply to all documents, whether they're recorded before the statute or after the statute, if the statute gets passed. Okay, the next question is, what are the implications if the minutes for the annual meeting a year earlier are not approved at the annual meeting this year? This is a common problem, actually. So let's say you're about ready to conduct the 2021 annual meeting, and one of the things that you should put on your agenda for discussion and vote is approval of the 2020 annual meeting, because you can't approve the meeting minutes from 2020 until 2021. So what do you do if you screw it up and you forget to do it? Really just wait till the next annual meeting and approve 2 years of minutes at the next annual meeting. It's not that big of a deal. It happens all the time. And, but some things that you can do to make sure it doesn't happen is make sure that the ballot that you're sending out has approval of the minutes as a vote in addition to election of directors, and that the agenda of the annual meeting also makes that a topic of discussion and vote. Okay, when writing the minutes covering the annual meeting, is there any legal requirement to say in there what was discussed during the question and answer part of the annual meeting with the homeowners? So no, there's no requirement to do that. Really, the meeting minutes for the annual meeting and the meeting minutes for regular board meetings should be what was decided It doesn't necessarily have to be what was discussed. Okay, the next question is from John. Do you foresee the statute on amendments? Wow, people are interested in this. Particularly House Bill 2619 passing. How would we prevent a vocal few, such as some coalitions in Arizona who dislike associations, from having a disproportionate influence on legislation? Okay, great question. Do I think the amendment bill, which would lower the requirement to amend CC&Rs, do I think that's going to pass this year? Possibly. I think we probably got like a 40 to 45% chance that passes. Although I've been doing this 24 years, and I can say that usually a bill of this nature, it takes a couple years of being introduced before something like that would pass. Now, this is the second year we've seen something like this, so it's possible it could pass this year. But this is going to be kind of controversial, and the state has a lot of other issues with COVID and political issues right now, and I'm not sure that they have the bandwidth to take this on this year. So we'll have to wait and see what happens. How can we, stop like one person, that's an angry homeowner from, influencing legislation? The best way to stop that is for all of us together to be contacting our legislators when there's a bad bill. And so when we see that there's a bill out there that's going to hurt our industry, make it more difficult for boards to conduct business, make it difficult for management companies to conduct business, you can bet, sure as I'm sitting here, that our firm is going to be talking about it on our Facebook page and on seminars, and asking all of you to reach out to our legislators to tell them you're opposed to these bills. So that's how we stop, one disproportionate person from, influencing legislation. Next question is from Eli. There is an item in the 2020 summary cheat sheet from the legislation that was not passed that says associations cannot prevent solar installation. I thought that was already the case. We have a homeowner who erected an unsightly solar flower. Can the HOA ask it be taken down? Okay, so here's the quick review on solar energy devices in Arizona. Associations cannot effectively prohibit the use of solar energy on that owner's property. The legislation that was introduced in 2020 is a fine-tuning type legislation that's going to continue to fine-tune the existing law. So that obviously didn't pass last year because no bills regarding HOAs and condos passed last year. So how do we handle the owner that has an unsightly solar flower? Delicately would be what I would say. I don't know if the solar flower is going to be considered a solar energy device under the statute. So we'd have to look at the specifics on that. Probably not, if I had to guess. I don't know how large it is, but usually the solar panels are being used to heat a pool or water in your home. And I'm guessing a solar flower isn't going to be that large. So, I'm kind of thinking here, like, pick your battles. This may not be a battle you want to pick, but I don't know. Maybe it's the whole front yard with the solar flower. So I'd have to probably see pictures to comment more on this. But can the HOA ask it be taken down? I think I'd be really careful on that right now, because there is a law that prohibits us from effectively prohibiting, and I'm not sure you really want to get involved in, $100,000 litigation over a solar flower. So talk with your legal counsel to determine, if it falls under the category of being a solar energy device and what remedies you may have on this situation. Okay, next question. Where can I find detailed examples of how to conduct voting for amendments to the CC&Rs? We'll look at our cheat sheet first. We shared that in the presentation today, and we're going to be sharing it in a link after the presentation today. You can also find it on our website at mulcahylawfirm.com. So you could also contact our office. We can give you a sample mail-in or absentee ballot for a CC&R amendment. If that would help you, feel free to reach out to our office. Just go to our webpage, like I said, at mulcahylawfirm.com, and reach out to us that way. Okay, the next question is from Harris. What is, from your practical experience, the best protocol when you are taking over the HOA board after the previous president was on the board for over 10 years and carried the same property management company? The management company is now being difficult and won't allow access to major documents and books. I have no doubt that we will replace them with other management company, but what is the best timing? Okay, first, Harris, I think you need to reach out to our firm because we can give you some suggestions on how best to deal with the management company in this situation. We see this situation, interestingly, all the time. So we have a board change and maybe the board liked a certain management company and maybe they let the management company, just do everything and they just kind of were very limited involvement. A new board comes in and they want to do things differently. They want to be more involved. They want to get things done and they want to see records and books. And obviously the management company works for the board and the books and records belong to the association and should be provided. Every document should be provided to the board. Okay, the homeowners, there are some documents that we talked about already in this presentation that we can withhold from the homeowners, but the board gets everything. I mean, it's your responsibility to be in charge of the association. You have to know everything. So I would say it does sound like it's time for a management company change if they're refusing to give you the records and you're on the board. And they're being difficult because let's face it, they work for you. We're a team, right, with the management company and the board. And the team members need to be respectful of each other. But ultimately, at the end of the day, the board makes policy and direction decisions regarding the association, and the management company takes direction from the board. So it sounds like you need a new management company. You may want to check out our cheat sheet on our website. We have one on how to select a management company. And if you contact our office, we can give you some suggestions on management companies that might be a good fit for your association based upon the size of your association, your geographical location, and what's important to your association, in terms of having a responsive management company. We can give you some good ideas for that. So reach out to us. Next question is from Joan. What are your thoughts on meeting rules for board chartered communities? Should they follow the same open meeting rules that the board must follow by law? Okay, so committees, let's just do a quick research on that. Under Arizona law, committee member or committees that meet regularly regularly scheduled board committee meetings, those do need to follow the open meeting law. Only committees that are regularly scheduled committee meetings need to follow the open meeting law. So if they have a regular meeting and it's every quarter or every month, they have to follow the open meeting law that we talked today. If they do not have regularly scheduled meetings, they do not have to follow the HOA and condo open board meeting law. Next question from Jose. Can I force my HOA board to notify me by email for open meetings, or am I required to check their website every 2 days for notices? You cannot force them to notify you by email. You could request it. But I would suggest, the law doesn't require them to provide you with the email notice. So I would suggest that you continue to check the website for the notices. Next question is from Christine. I am a homeowner, former condo board member in an association still controlled by the builder. Is it hard to get any information or response from the property manager? Oh, you're saying it is hard to get any information or response from the property manager. Only one meeting a year is required at this point. Any advice? Okay, so it shouldn't be difficult to get a response from the property manager. So I think what you should do is attend your next board meeting and mention to the board in the homeowner forum that it's difficult to get a response from the manager. And you just want to make the board aware of that and then ask the board to help you with whatever question you need a response on. Only one meeting a year is required at this point. Is that because you're under developer control? I don't know. I doubt it because you're saying that you're a former condo board member, but maybe that was in a different association. Under Arizona law, you are only required to have the annual meeting every year, but typically in the association's bylaws, it requires you to have a regular board meeting on a significantly more frequent basis. Most of our boards meet every month, with the exception of maybe December and maybe some summer months where they can't get a quorum. It's unusual if you're post-developer controlled that you only have one meeting a month. And so I think that's a good question to ask your board. How can you conduct business if you only have one meeting a month? Next question is from Sandy, one meeting a year. Next question is from Sandy. Do votes have to be unanimous at virtual meetings as it has to be if using email? Well, good question. So no, it doesn't have to be unanimous at a virtual meeting. Arizona law allows us to have virtual board meetings as long as everybody can hear each other. The homeowners and the board members everybody can hear each other. And so, it does not have to be unanimous. It just has to be a quorum present, and then a majority of a quorum makes decisions for your association. Okay, the next question is best practices. Should public forum take place prior to the meeting being called to order or after the meeting has been called to order? Honestly, it really doesn't matter to me. I think it can be done either way. But best practices probably would be to call the meeting to order and then have the homeowner forum. The next question is from David. When an HOA board indicates they're having an executive session, they must state what section of the law covers the session. Must the board also state the nature of the subject, such as employee issues, financial issues, legal issues? My suggestion would be yes, state the specific section under the law that they're going to be discussing, and have the name of that specific section listed as well. So if you're going into executive session to discuss, legal advice from your attorney, you should list the section under the statute that pertains to that, and then say, legal advice from our attorney will be discussed. The next question is from Mary. What are the requirements for minutes from board executive meetings? Confidential info that can't be shared. Okay, so basically the minutes of the executive session should be set up just like the regular session meeting minutes. And it should indicate, the date, the time, who attended the executive session, and any decisions that the board made. And those minutes are confidential and will not be disclosed to anybody other than the board. Next question is from Wally. Can members, i.e. non-board members, question or challenge the minutes before they are approved by the board? So yes, remember we talked earlier in this presentation that before the board takes formal action on something, the owners should be allowed to participate if the owners want to. If you don't agree with the minutes, you're welcome to make a very short statement, just saying that you don't agree with them in whatever capacity that you feel that you don't agree with them. But you can't. Basically, it'll just be noted that you made a comment, and the board will continue to vote on them. So you're welcome to make a statement at that time, a short statement, but it doesn't stop the minutes from being voted on, and your statement doesn't have to be included in the minutes. Ultimately, the board makes the final determination on whether the minutes of last month's meeting minutes are approved at that meeting. Okay, let's see. The next question is anonymous. What can an owner do when they know a board is violating the open meeting board rules, board meeting rules? A couple suggestions would be, you might want to reach out to the board and just make them aware of the open meeting law in Arizona. You could provide them with our cheat sheet on open meetings, and just state that it's my opinion that you may be violating the open board meeting rules. Here's a handout on this topic. If you continue to think that they're violating the rules, the open meeting law rules, you have some different legal remedies. I would first start by writing a letter stating why you believe that's the case to the board. If they continue to do it and you believe they're violating the law, you can go to the Arizona Department of Real Estate and file a complaint against the association. There is a filing fee to charge, they will charge you. It'd be $500 for one issue. And you can have an administrative law hearing on, are they violating the open meeting laws? You can go to Superior Court and file a lawsuit against the association to require them to comply with the open meeting laws. I think those are some good creative suggestions on how you can handle a problem and how you can escalate it if the problem isn't being resolved. Are email rules the same for HOA committees? Yes, it really just depends. Remember, the open meeting law only applies to committees that meet regularly. So best practices would be that using email, for regularly scheduled committee meetings could potentially violate the open meeting law. For HOA committees that don't regularly meet, they can use email to conduct business. Can you remind that emails need to be separate from the person's work email or personal email? in case of a subpoena. So it's, Jill brought this point up. It's best practices for association board members to have a separate email for their board communications. And this is in the event that if there's a lawsuit and their emails, there's a request for production of documents or a subpoena, that the board's personal emails wouldn't be intermixed with the association business. And it would, ensure that the board would have privacy on their personal emails. So I do think it's best practices for all board members to have a separate email just for association business. Next question is from William. Can you please discuss committees, how to form one, who can be on one, what committee charter is? Thanks. Okay, we have a cheat sheet on committees on our webpage. So I would encourage you to go there and look at it. So it's www.mulcahylawfirm.com. Okay, so committees, it really just depends on what committees your association has. Typically, the committees are set up in your CC&Rs or bylaws. And it will also talk about how to form a committee for your association and who can be on the committee and, that type of thing. It also will typically list what's the charter for those committees. If your board wants to deviate from, or add a committee that isn't in your bylaws or in your CC&Rs, the board would be the one that forms the committee. The board appoints the committee and the board determines who's on the committee and what the charter is. And this would all be done by a majority vote. Next question is from Crystal. Is it allowed for the current president and others running to walk door-to-door campaigning and collecting ballots? So short answer, yes, that is allowed. Okay, the next question is from Anonymous. Is it good practices to hire unlicensed, uninsured, and non-bonded handyman to perform tasks on community property, such as plumbing, electrical? Is the entire board liable for the decisions of a single member or those working members working independently of the entire board? Okay, so first thing, we're going to be talking about this, I think, in either the next class on our Virtual HOA Academy. It's one of the topics, or the fourth class. I can't remember exactly, but we're going to be talking just exactly about this subject, hiring of licensed, insured, and bonded contractors. So best practices is always hire a licensed, insured, and bonded handyman for your association's repairs, for any construction work, roofing work, etc. That's best practices. There may be some limited, and plumbing and electrical, which is your example right here, mandatory. You should be hiring licensed, insured, and bonded handymen. There may be a time where you don't want to hire somebody who's licensed, insured, and bonded if they're just changing low level light bulbs, and you don't want to pay the fees for that. Just recognize if you hire somebody like that, there's a risk, and you have to weigh the potential liability of the association if that person should get injured, with the benefit of paying that person less money for doing the job. But best practices is, in my opinion, please hire licensed, insured, and bonded contractors. And the entire board would be liable for the board hiring, an unlicensed, unbonded, and uninsured person, and that person getting injured, not personally liable, but the association, would be held liable in the event that, there's legal liability that's determined. Okay, pending legislation may allow the cities to regulate short-term rentals again, correct. Yes, there is legislation. There was legislation introduced in 2020. We're seeing similar legislation this year that would, give back to the cities the right to regulate short-term rentals. I'm not sure that the cities are going to want to, though, frankly, because there is revenue that's coming in from, the short-term rentals in different associations. So if this law passes and it goes back to cities, towns, and municipalities regulating short-term rentals, every city, town, or municipality is going to be able to make their own choices on that. And I don't know what those choices will be. The next question, we have about 13 questions left. Is that about right? 13, or is it 13? I think about 13. We're on number 27. Okay. What am I to make of a 3-member HOA board, 70 single-family homes in our community? That doesn't seem to meet virtual or otherwise, except for an annual meeting, and no one except me attends. I've never seen a meeting announcement or agenda. Also, I heard that I have been recently elected to the board, but neither of the other 2 board members nor the management company has made contact with me to let me know. Is this common? Short answer would be no, this is definitely not common. Okay, so if you are, still serving on your board, if you are serving on your board, you should reach out to your management company directly and say, it's my understanding I've been elected to the board and we need to be following the law. And, you might want to provide them with our virtual meetings cheat sheet. And, you need to reach out to the other 2 board members too, and just say, hey, I think we need to schedule a meeting so we can discuss association business. Okay, I just got notice that we have about 20 questions left. I'm going to keep plugging through all of them as we go. So just bear with me. Most of these look like they're pretty short questions, so it should go pretty quickly. Next question is, how should HOAs establish an emergency contact information list for elderly members, and what is the HOA liability? Okay, the association doesn't have any legal obligation to have an emergency contact list for your elderly members. So just know that that's not a requirement. Do you have liability on this? No, you're not a care home. Associations it's not one of their responsibilities or legal responsibilities that you have to do. If an association does get an emergency contact information list going, you need to indicate specifically that, hey, if the information needs to be updated, it's the responsibility of the owner. And this is something that, may or may not be updated going forward. And, we have no liability. It's just, it's for information only, and we'll keep it with your records. Next question is anonymous. Can a maintenance vendor remove trees and or shrubs at their discretion without notifying the homeowner? That's a great question because we see lawsuits on this. So really, vendors of the association take direction from the board. And so if the board tells them to remove a dead tree or relocate something, they should be taking it from the vendor, right? And the board should be giving direction to the vendor. So should a vendor be just doing this, without any board direction? Likely no. But sometimes the board gives the maintenance vendors a lot of leeway and discretion in determining this. So I would just reach out to your board, find out what their position is on this, so that you better understand. It sounds like probably maybe something was removed from your property. Okay, next question is from Paula. How do you handle homeowners and residents decorating common areas when it has not been enforced and there's no documentation submitted for board approval? Well, first of all, if somebody's decorating the common areas, it would be unusual. Only the board would be, allowed to make a decision to whether or not to allow a homeowner to decorate common areas. And I don't know if this is like for Valentine's Day or St. Patrick's Day, or if this is something that's going to be up all year. Really, homeowners and residents shouldn't be doing that without board approval. So if somebody has done it and you know who they are, maybe the board should send them a letter asking them to remove it, and requesting that anytime they do this in the future, that they would need to get prior written board approval. Next question is from John. How would you recommend the board go about addressing the issue with unhappy litigious homeowners? Okay, this probably could be a whole class, but what I will tell you is that if you have unhappy litigious homeowners, do your best to communicate with them. Try to open up the lines of communication, see what they're upset about, see if you can help them in any way so that they feel more comfortable with how things are going in the association. Invite them to come to board meetings, be transparent, be nice. That's my best advice. Sometimes, even when you do all of those steps, they're still litigious and they're still unhappy. And in those cases, make sure you get your legal counsel involved to help you manage the problem. Because when you have unhappy litigious homeowners who aren't reasonable, you typically do need to have legal involvement to help you manage the situation and to help you so that you don't get sued by them, going forward. Next question is from anonymous. What can an owner do if the board ballot includes a candidate that is not eligible to run because they are not the record owner? Believe it or not, we see this often. So by mistake, somebody who's not on the deed is running for the board, and there's a requirement that all board members have to be record owners. So how do we handle that? We go to the non-owner and we say, can you be added to the deed? In some cases, they're quickly added to the deed like a 1% interest, and that would qualify under most bylaws to let them run for the board. In some situations, they can't be added to the deed. And in those cases, if the board has time, the board should send out a notification to the membership that that person is no longer running. I wouldn't embarrass them. I would just say that they're no longer going to be a candidate. If it's too late to send out a notice like that, obviously, if that person gets enough ballot votes to be elected, they would not be elected, and the next highest vote getter would be elected to the board. Are there board member term limits? Under Arizona law, no. Some association documents, very rare, have term limits, and that would typically be in the bylaws. But again, it's pretty rare. We don't see that very often. Do you have strategies for dealing with a CC&R 100% mortgagee written consent requirement when it comes to amendments? Or do you believe, as some do, that the state statute trumps the CC&Rs when it comes to process? So I don't believe that the state statute trumps the CC&Rs on that process, just as a starting point. And I do have a strategy for dealing with these mortgagee written consents. If your association reaches out to our firm, we can help you with that process. There is a workaround loophole that we do, and it meets the requirement. We also amend that section out of your documents so that you don't have to deal with it in the future. So John, please reach out to us. We're happy to help you strategize on that. Number 35, anonymous. Do architectural guidelines created independently of the CC&Rs need to be approved by the entire community? Typically, no. The only exception to that would be if the CC&Rs require that, but I mean, that'd be very, very rare. Typically, the architectural guidelines are just approved by the board. Next question is from Crystal. Our HOA Legal Council is only allowed to be contacted by the president. The president is the one in question. She has been on the board for 18 years. We should have 250,000 and we only have 89,000. So I don't see a question there, but I would say this, that, typically there are procedures for who can contact the HOA Legal Council. And sometimes it's the manager, sometimes it's the entire board, sometimes it's just the president. But homeowners are never allowed to contact the HOA Legal Council and talk to the legal counsel without board approval. One thing that you might want to do if you're really concerned about the funding in your association and the fact that you think there's missing money, which I think I'm reading between the lines, is you could write a letter to or an email to the association's legal counsel and make the council aware of the situation and ask them to look into it. And you can sign your name as a concerned homeowner. And I would also CC the board on that so that they don't think you're going around them. Next question is from David. What would be a normal fine amount for short-term rental violations? The normal fine amount would be whatever the short-term rental going rate is for a night. So if they're charging $300 a night, the fine should be $300. I think that's reasonable under the statute. Next question is from Jim. Are there any legislative actions in process to require reserve funding? As of right now, no. 39, Jill, can owners see a management company's contract? So this is kind of a loaded question. So my personal opinion as legal counsel for association is that association should give the management contract to any owner who wants to see it. Here's what the law says. The law says that we can redact how much we're paying the manager and their Exhibit A, which typically outlines all their extra charges. So, if they want to follow the black letter of the law would say that if an owner wants to see a management company, the board has the option to redact how much the management company is being paid. But they'd have to provide the rest of the contract. But I think it's really not a good idea to do that. And here's why. Because the owners can see by looking in 5 other places how much the management company is being paid. They can look at the budget, they can look at the check register, they can look at the bank statement. There's a number of different places they can look. So why would we play the game of redacting how much we're paying the management company? It just doesn't make sense to me. And I think it makes the board look like there's a lack of transparency. And so I recommend as legal counsel that you provide the contracts for all of your vendors to the owners if they want to see them. I mean, it's not that often that they do, but if they want to see them, they're entitled to see them. Next question is from Paula. Can you explain again problems with the email exchange with all board members? Okay, so sorry I wasn't as clear as I wanted to be on that. Okay, so Paula, here's how email exchange, works with board members. Please do not discuss association business via email. Please do not vote on association business via email. Okay, the only exception to that is when there's an emergency and you can't wait 48 hours to notice a regular board meeting. And in that case, remember, you have to keep all the emails showing what the decision was and why this was an executive session, emergency, why this was an emergency, not an executive session exchange that needed to be conducted, and what the actual votes were. Okay, so what the problem is that sometimes boards hit reply all, like maybe the manager sends an email that says, here are 3 tree trimming contracts, and they send it to everybody on the board. That email is okay. What's not okay is if one of the board members hits reply all and replies to a majority of the board, I vote in favor of number 2. And then everybody else starts chiming in, reply all, I vote in favor of number 2 too. You've just discussed and voted on email. It's not an emergency situation. And that type of discussion needs to be done during the open meetings. And the law is really clear on it. And it's evolved over the past, 24 years that I've been practicing in this area. It's very clear that the legislature intends that all association business is conducted in the open board meeting, unless it's a subject that's in the executive session, topics that they can go into executive session for. And email is something that boards trip up on. So just be really careful that you're not making decisions or discussing things with the quorum of the board anytime by email, unless it's an emergency circumstance. Okay, next question is, if a reserve fund is a best practice and not required, what is an adequate funding percentage that you would recommend? Okay, so a reserve fund, it's best practices, of course, to have reserve, which is going to be, an account, savings account for, long-term planning for your association's assets. What's an adequate funding percentage? I don't know. For your association, every association's different. The best way to find that out is to hire a reserve company to come to your association and provide a reserve study. And that will tell you exactly how much needs to be in your reserve and, what an adequate funding percentage is. So on some reserve studies, they'll say, like, if you're funded between 50 and under percent, you're in a danger zone. If you're funded between 50 and 70%, you're in an adequate zone. If you're funded 80% to 100, you're, adequately funded, and you're in good shape. So really, it just depends. I mean, kind of a rule of thumb would be if you have like 70 or 80% funded from a reserve study, you're in good shape. Okay, anonymous. With the Open Meetings Act in mind, should the board limit the amount of board members that can be on a single committee? Well, one thing I haven't mentioned that it's just kind of been bothering me that I haven't brought up in this call is that, remember that the architectural committee needs to be chaired by a board member. So I want to make sure that that's clear. And I guess the question here is, when you have an open meeting law, if you have a quorum of the board serving on a committee, could that be considered a board meeting? Yes, it could. So you should always have less than a quorum serving on a committee. Sometimes we have associations where the committee meets and several board members show up. So, and now they have a quorum because they've got maybe 2 people on the committee that are board members, and then another board member shows up as an attendee. Just be mindful that the attendee, whoever the person is that's making the number to be a quorum, they shouldn't be commenting. If they're present, they're just present there. They shouldn't be commenting or voting on anything. And that will be a way to, be in compliance with the open meeting law that pertains to board members. Next question. If email is inappropriate and or illegal for board business, I guess that text messages are even more discouraged. Can I safely discourage my fellow board members from conducting business via text and point them to the next regular meeting, or at the very least email if there's an emergency? I would say, this is from owner, I agree with you. You shouldn't be texting association business, to get around the open meeting law. So a good suggestion, like you said, is to point them to the next regular meeting, just because we don't want to violate the open meeting law. The next question is from Karen. If the association has a social event and all the board members, let's see here, and all the board members attend, how does the notice affect this situation? As long as the board's not discussing association business at the social event, quorum of the board discussing association business at the social event, they don't have to notice it as a board meeting. And it wouldn't be considered a board meeting because they're there in their personal capacity and they're not discussing association business. Okay, next question is from John. Could relaxing enforcement on items such as flags result in issues with inconsistent application of restrictions? Possibly, but unlikely. It might, other people might say, well, can I have my flower flag because there's this, rainbow flag here? Possibly, you may have to relax it for other flags, but it wouldn't, the relaxed enforcement on like a Black Lives Matter flag, in my opinion, wouldn't result in, an argument that the CC&Rs are invalid or anything like that. So the next question is from Harris. Please, can you come out with the most common areas which could upgrade the community value? For example, build the community gate, the fitness area. Honestly, Harris, I'm probably not the person that's the best person to comment on that. Here's a couple things I can say from a legal perspective is if you want to upgrade your community value, and I'm not just talking about dollars, but I'm just talking about like the health of your association, have a strong management company, a good management company that acts at the direction of the board, and the board should be professional and following the law, and have a legal counsel that is well versed in this area of the law and that is looking out for the best interests of the association. Stay out of lawsuits, try not to get involved in lawsuits, make sure your reserve fund is adequately funded, stay within your budget. Take a look at our successful associations cheat sheet, how to have a successful association. It's listed on our website at mulcahylawfirm.com, and that can give you some tips on how to have a successful association. Now, if you want to talk about how do we get more dollars in the door for our association value, property values, talk with a realtor, because there is some argument that if you have a community gate or a fitness area that's more high tech and up to speed with what younger residents want, it may increase your property values, but I'm not the person for that. That would probably be a realtor that sells a lot of properties in your area. Okay, is an HOA allowed to change its fiscal year? Only if you amend your documents to change it. You also should be consulting with your CPA in that case. I thought federal law only covers service animals, not emotional support animals. No, the Fair Housing Act also covers emotional support animals. I encourage you to check out our cheat sheet entitled Federal Laws on our webpage at mulcahylawfirm.com. We're just going to have to finish up with a few questions. I think I have 3 more because I have to go to a board meeting here in about 8 minutes. So the last 3 questions are, how do we handle a renter in our community who parks 6 or 7 cars, trailer, and a house full of junk furniture? It's like a hoarder's home. Honestly, I think the best way to handle that person would be to have your attorney contact the owner and make it hurt in the owner's pocket by fining the owner, possibly escalating this to litigation. You're welcome to reach out to our firm to help you with that problem if you need help. We've successfully dealt with many hoarders in the past. Last 2 questions, Dolores, what recourse is there if the board has conclusively stated they will allow a particular visual violation to the CC&Rs or architectural guidelines on one property, while also saying the neighbor's complaint is valid per the CC&R architectural guidelines, but that they, the board, will still allow the violation to stand and the complaint not to say anything further about it. And if they do, they are proven to be considered as a troublemaking gadfly. Okay, oh my gosh, this is crazy. So this is kind of a long question. I think probably we would need to talk about this offline. So if you want to, talk a little bit about this with me, you're welcome to contact our office. It's kind of hard to comment on it because it sounds like there's a lot of backstory on that one. Last question. I am a homeowner, former condo board member in an association still controlled by the builder. Okay, so this might be the one that was similar to the first one. Is it hard to get any information or response from the property manager? Only 1 meeting a year is required at this point. Any advice? So what I would say is, since you're under developer control, I would find out who the management company is, and I would send a records request to the management company. They will know that they're required by law to follow the records, providing records to under the records law that says that owners can see records. I would also reach out and look on the Arizona Corporation Commission's website, find out the names of the directors that are currently serving under your developer controlled board, and also send them a letter asking them for information and letting them know that you wish that they would be meeting more than once a year for their annual meeting, and see if you can get a response. Okay, just some concluding remarks. We got through, if you can believe it, 51 questions. That's pretty good. 51 questions in 50 minutes. How about that? Some concluding remarks for today. Don't forget that our third class for the spring 2021 Virtual HOA Condo Academy is on Tuesday, March 16th at 11 a.m. Our topic for the next month will be the ABCs of enforcement, which I think we can all agree we had a lot of questions on how do we handle violations and enforcement in our community. And we're going to be talking about violations, fines, lawsuits, rental issues, parking problems, refusal of owners to pay assessments, and a lot of different topics. So we hope you'll be joining us on March 16th, the day before my favorite day of the year, March 17th, St. Patrick's Day. And we're going to be at the same time, 11 a.m. And we're going to be conducting the class again via Zoom and also via Facebook Live. So thank you so much for being here with us today. We appreciate you caring about your communities and wanting to learn more about the law regarding HOAs and condos. And I'd especially like to thank the different cities that are partnering with us here today to make these classes possible. And that would be the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, and Tempe. We appreciate the opportunity to partner with these cities, and we really have positive things to say about these cities because they care about their homeowners. They want to have good associations, and they want to provide useful information to their homeowners, board members, and management companies during this pandemic time. So thanks everybody for being with us here today. I hope you have a great rest of the month, and I look forward to seeing you next month for our third class in the Virtual HOA Academy series. Take care, everybody. Be safe.